Welcome to this presentation of your divorce options in Washington State. My name is Meg Gluckman. I am a co-parenting and divorce coach.
Hi, I'm April Benson, and I am a family law attorney.
Today, we're going to walk you through your different options as you navigate divorce in Washington.
This presentation is just for information purposes. It's not meant to convey legal advice. There are a lot of different ways that people go through the process of divorce, sort of legally speaking, and a lot of folks don't know about these different services and different options that are available to them that maybe not as expensive or as time consuming as you think. This is a beautiful handout created by a local organization called King County Collaborative Law. It also applies outside of King County. King County Collaborative Law is an organization of professionals who work on collaborative divorce and other family law matters, sort of solidly in the middle of this chart here. But I want to talk to you about all of the options available on this chart and what they might look like. I'm going to start off at the very bottom of this, and then we'll talk through each little window. Looking at those arrows on the bottom, the first one is average cost, which talks about how much different processes might cost in terms of how much time and money you are spending on professionals and on court costs. So the left side of this diagram is on the low end, and the right side, which is the court side, is the high end. And it's not a straight line. Things will vary depending on what's going on for a particular family, but on average, that's kind of how that goes cost-wise. And then the reverse is true as far as party involvement and control of outcome, just the second arrow there. When folks are able to entirely work through the decisions that they need to make together in what professionals often call the kitchen table approach to a legal decision or a divorce, they are highly involved and they have a lot of control of the outcome of it, which is great. Moving along through the windows, it goes to the extreme other end, which is a court making those decisions for you, which means that the parties lose control of the outcome.
Great. I'd love to just dive into kitchen table and talk to folks about what that entails.
Great. The kitchen table approach is where most people start. And you'll see here, each little diagram has color-coded little people for who's involved in how. This is the approach where the two members of a couple are sitting down together to talk through the different issues that they need to decide in a divorce. There's so much to talk about that is far too much than we can cover in just this presentation. But generally, the sort of three big things people need to cover are financial division of property, a parenting plan, and child support. Those are kind of the three big areas. So here you'll see it's the two people working directly together. There's a blue line to kind of indicate who's in the room and who's not. This is showing that each party might have an attorney outside of the direct negotiation, but someone to consult with and give advice and maybe help with writing up the agreements or any court documents that are needed. But the direct decision-making is happening directly between the two members of a couple. This is a step up from kitchen table approach. And I did mean to say earlier that you don't have to decide from the outset what you want to do. A lot of times folks start with kitchen table and then they might realize that there's a sticking point. So maybe they can agree on everything related to parenting, but they're not sure how to divide up financial resources. So they decide to seek some more professional help. And one way to do that is in the form of a mediator. So you agree and bring on a neutral third party to help talk you through the issues. This would be someone who's trained to help with dispute resolution, and they can help come up with ideas and facilitate a discussion to help you reach a resolution. There's that blue line to sort of indicate who's in the room and who's not. In this scenario, the two members of a couple are there, the third party neutral is there. They're the ones coming up with the agreement. But there are other folks outside of the negotiation process who can be supporting you. It can be an attorney like myself or another family law attorney who's advising, maybe helping with document drafting. This diagram also indicates that there could be a child specialist if there's particular family needs, and Then there's the great person is another general specialist.
It might be a co-parenting coach. I would just throw in that even if you're doing the first option of the kitchen table, you might also lean on support from someone like a financial advisor or a child specialist or a co-parenting coach to help you along the way.
They're experienced and have great skills and abilities to help support people going through these processes. Another step up from that mediation, it may be that you start with just the two of you and the mediator. And then the mediator is likely to be able to give you some guidance to say, you know what, there's more going on here than I think we're going to be able to address just the three of us. I think you might really benefit from having some attorneys. Or maybe you know from the outset that you want to bring attorneys into this process. It's just sort of having another person on your team there to support you, there to help get your needs and priorities stated so you don't have to do this alone. In this model, both clients are in the room, they each have their own attorney in the room, and there's still that third party neutral mediator to help facilitate the conversation and keep things moving forward. And again, just like everywhere, outside of the negotiation process, you might have other specialists like a coach, a child specialist, someone financial to help give information and help you figure out what it is you need to know to resolve these questions. And the next model up, this is what I was mentioning before, is the standard practice that folks who are members of King County Collaborative Law are working on and other collaborative attorneys. This is a particular model in which there's no longer a mediator in the room, but what we do is we put together a professional team to help a family go through the decisions and the process of getting the divorce. Here it's both parties, they each have their own attorneys. And in this model, you bring the financial expert and a coach directly into the room and you have meetings of everyone. It's sort of like a one-stop shop where you have your own person with you, your own attorney, and any questions that come up about the finances, the financial person who is part of the team is already there and can help answer and can help talk about the specifics of the case or talk about ideas of what they've seen. The coach is also there to help facilitate. They're not a mediator, but they are there to say, hey, this is getting really heavy. We might need to take a break, or to help set the tone and the scope of the meeting.
I would love it if you would talk a little bit about the participation agreement and what makes using collaborative attorneys different than using standard litigious attorneys.
Great question. So you would have a participation agreement both for this full collaborative practice model as well as for a collaborative mediation model. The difference between this and then kind of like the more standard adversarial model is that you sign an agreement that allows some waiver of attorney-client privilege. So in kind of the standard model that people may know from past experience or from TV, anything that a client tells their attorney with certain limited exceptions is privileged and remains confidential through the process. In a collaborative model, in order to facilitate communication and a smoother path toward dispute resolution, the parties all sign an agreement saying that they will waive that privilege as within the professional team. This allows the attorneys and other professionals to speak with each other, quite frankly, about what's going on, reduce surprises, reduce gamesmanship. It's just a more transparent process that everyone's aware of and agrees to at the outset, that really allows that team to work together effectively to help the family come to a good resolution that's particularized to their family needs, and also potentially one that's more efficient than going through an adversarial process because everyone has the same information from the outset. You're not having to hire separate experts like financial experts, for example, or child experts, because as a group you have chosen, this is the financial person that we want and trust. This is the other specialists that we want and trust involved. We often say, like, you're doing one last big project together as a family unit. The project is getting your divorce, and so you're hiring a team to help you walk through that.
And I just want to emphasize the word team. I love that so much. Instead of two attorneys that are kind of standing up for their clients and working at odds to each other, the collaborative practice is really about a team that works together to get to the best resolution.
Yeah, and this is a relatively new type of practice in Washington. I mean, I say that it's been like 20 some years, but it's still growing and it's still a thing that a lot of folks don't even know is an option. They assume they need to go hire someone to fight for them in court, and that's not at all the case. We can set up these teams, we can hear everyone out, we can come up with resolutions that really work for the family as a whole and take everyone's needs into account. And the family can propose a lot of different creative solutions that like we professionals might not even think of. So it works well for everyone. Also, clearly I'm biased towards this process because that's where I like to practice.
One other thing I want to just point out here, both between the collaborative practice and the collaborative mediation, is that you and your former spouse don't have to be best friends in order for this to happen. You don't have to be singing Kumbaya or holding hands coming in, or even in agreement about most things. That's not necessary. All that's necessary is that you're able to work respectively together, that you can work within this team, and that you're both interested in coming to a resolution outside of court.
Yeah.
That's what's necessary.
And a lot of people seem to resonate also with the fact of like recognizing it just means your family is going to look different in the future, but it's still going to be a family. Whether from adult children, because it's been a longer marriage, or whether they're still minor children, they're still co-parents. They're still going to have a lot of potential, future ties to each other. So agreeing to go through this process means you're agreeing to do it in a respectful way. We always say it doesn't avoid conflict. We just help you hold the conflict better. Coming back to the big picture here to show you, we've been through like the first left half and middle of the table. The difference here that will switch is where that blue line is. Up through this point, it's been the two members of a couple who are remaining in the same room with each other as they work through these negotiations. They're communicating directly with each other. They may have support from attorneys, whether in the room or out of the room, but that's all part of it. The next part of the conflict options diagram, the blue line shifts, as you can see here, to a vertical shift where the parties are no longer in direct communication with each other. I do just want to acknowledge this is 100% what some families need and what's best for folks depending on the circumstances. There's no one way that is best for every family. There could be a variety of reasons for that, but just acknowledging this is where we're moving toward in this sort of left to right scale as far as how much support you need, how much party involvement there is, and how much control of the outcome it is. This next level is attorney settlement. And as you can see, the two people who are in direct communication with each other here are attorneys. It's no longer the parties. The parties might each have their own specialists, financial and otherwise, to be guiding them and giving them information. The parties are no longer themselves directly communicating. In all honesty, I think this is probably the way that most divorces in Washington resolve, at least ones where attorneys are involved. This is often what people think of. They think, I need to go hire an attorney. My spouse needs to hire an attorney. The attorneys will talk to each other. We might be going to court eventually. We don't know. But the attorneys and everyone want to avoid that if possible. And so they'll be talking with each other. They often come up with a way to resolve everything. Agreements are signed, court orders are entered as agreed orders, and then it's the sort of next level up from that. If the attorneys are not able to negotiate an agreement between themselves or between the parties for them, is a settlement conference. Some people also call this process mediation. I generally call it a settlement conference. It's a different kind of mediation. And in this world, the mediator doesn't actually bring everyone to one table. Instead, they kind of shuttle between the two sides. The attorneys at this point of the process are no longer directly talking with each other. They're keeping their clients and experts apart, and a mediator is shuttling between them to see if they can help achieve an agreement. Now we're at the farthest right option from the original diagram. This is the sort of backup measure and place a lot of people tend to think of when they think of getting a court involved in their lives. In this model, we have a judge at the top. Each side is there presenting their own case via their attorneys. They have their own specialists and experts. They each get an opportunity to tell the court what it is they want and what they think is legally and equitably fair and the right outcome. And then the court makes the decision. This is why this is at the far right side of this scale, because it takes the party's ability to control the outcome almost completely away. It also will cost the most because you're paying for attorney time and expert time and dealing with all the things that come to that. It also, again, is just sometimes where a family needs to end up. I think of the court as there as sort of like a backstop. Like, we as a society have established courts for a reason, to help with dispute resolution when we can't do it. You might be starting way on the left side, but there's like one sticky issue that you are not able to work through, whether through mediation, any sort of collaborative process, hiring attorneys, those attorneys attempting to negotiate. It might be that that one little issue ends up at the court and not your entire divorce. All of these things are kind of on a spectrum of what's being decided and who's deciding it. But this is at one extreme end, is someone else is deciding for you, and all you get to do is make your best arguments to the court to ask them to decide in your favor.
I want to emphasize one part of what you said, which is you can start as far left on this diagram as possible and achieve a lot, make a lot of decisions, come to a lot of agreements. Say, for instance, you start at the kitchen table and you and your partner are able to figure out the parenting plan, but division of assets is a sticky point. You can take that to the next point to the right, to go to mediation. You can go to mediation and share that we have the parenting plan pretty much worked out, but we're stuck on dividing up assets. Who's going to get the house? How are we dividing retirement? All of that kind of stuff. So just knowing that you don't have to decide upfront how or which part of this process you're entirely going to use for everything. You can use different parts of the process for different parts of your divorce.
One thing in a similar vein to note is it's sort of easier to go from left to right than it is from right to left. Mm-hmm. You want to think about that as you're considering hiring professionals. And if you just have a sense of where you might want to go, and it's somewhere on the left side or middle of this page, then you probably do want to consult with an attorney who does collaborative work, because they might be able to consult with you and say, you know, I think maybe you could really work this out with a mediator, and you can just come consult with me when you have questions. That's like both a cost savings and a time savings to you. But if you start out with a family law attorney who's a regular litigator, it's going to be a lot tougher to back up and say, just mediate this. Instead, what you're likely to get is an attorney settlement, which might be absolutely fine for you, but it's just harder to move left and to back off of the adversarial process than it is to ramp up to it, and only for those things that you really need it for.
We hope that this has been a helpful presentation and that you feel a little more informed about what your options are for divorce in Washington State. And thanks for watching.